Cloud9 Fin, where we talk about everything corporate credit. My name is Max Frumes. I'm the global head of distressed debt and LevFin. And joining me today is a trio of partners from Debevoise. I have Sid Levinson here, the co-chair of the restructuring practice and luminary in the restructuring space, and Scott Selinger and Weisgerber, who are also partners at Debevoise, who are two of the three co-heads of Debevoise's expanded liability management and special situations group, with Scott as an expert in leverage finance and Erica in litigation, showing you just how expanded liability management has become. And today, we're here to talk about one of the transactions that really started it all, and get into connecting those dots to present day. And this was the 2017 uptier of Not Your Daughter's Jeans, or NYDJ Apparel. That was a transaction that was really the first up tier that was called an up tier even before Serta, which gets a lot more credit for being the pioneering up tier transaction. And it took place at the end of towards the end of Caesars, which Sid was also involved in, and around the time of J.Crew, and really maybe doesn't get enough discussion because it was ultimately settled. But the up tier took place. It was a group of majority lenders led by Mudrick, who struck a deal with the company that needed some liquidity and some relief to provide them with new money and up-tier their credit, their debt, while leaving similarly situated creditors in a subordinated position. Now, the agreement was unusual because the sacred rights expressly provided that a majority of the term loans could amend the waterfall. And so it, in today's world, seems like it would have been a lot looser and easier to do that than it was back then. Minority lenders led by Octagon sued, breach of contract, implied covenant, fraudulent transfer claims, and then after the state court expressed some distaste for the transaction, it was resolved. So that was just brief. Sid actually lived it and represented Mudrick, who were, some would say, the perpetrators of the up tier on the creditor side, or the creative visionaries who saw how distressed debt investing was going to become. So could you provide us a little bit more detail and kind of set the scene for the NYDJ transaction?
Sure. And thanks very much for having us, Max. We really appreciate being here. I creative visionary, I think, is, as it turns out, a decade later, I think actually the right description. And this really came from the client. I'd like to say that I could take credit for this, but the client came to us, and this was back in 2016, and asked about this particular sacred right that expressly allowed a majority in interest of a class with a capital C to change the pro rata provisions. And so, we looked at the provision, and I was at a prior firm at the time, and had one of my partners look at it, a finance partner. We looked at it and we were like, well, that's what it says. But, obviously you need to read a lot more of the document to really see if it works. And we did, and it did. I mean, it just flowed through in a way that it was just quite clear on its face that it was permitted. And so we approached the company with an idea for a transaction in which new money would be put in, and it was going to be $20 million, and then that money would be made available to offer discounted purchases to the minority group, and then the waterfall would be changed so that the participating lenders, which was our client and one other actually that comprised a little bit over 50%, would be first in the waterfall. So we took it to the sponsor. Davis Polk was representing them. The finance lawyer who was involved, they had some initial skepticism, but they looked at the agreement. they read it the same way we did. I think it was sort of one of these things where everybody was like surprised. And so then we, as I say, we had another member of our group. They were represented by Ropes and Gray. Ropes and Gray looked at it. They came to the same conclusion. We had a revolver lender that we needed to be a part of the transaction. I think they were represented by Otterberg. They looked at it. And again, it was the same thing. All of us, and again, this is 2016, 2017. By now, it's 2017 by the time we're actually negotiating the transaction. So we went forward with it. The reaction from those that were not in the group was not positive. Got lots of phone calls. And then it was pretty quiet for like 5-6 months. And we just thought, look, they read it the same way we did. And that's the end of it. But I remember it was when the Dodgers were playing the Astros. It was like Game 7 of the World Series. I'm from LA, and I actually represented the Dodgers in their bankruptcy, so a little bit of a Dodgers fan. And that's when they moved for a TRO, which they didn't get. But Justice Ramos was he wasn't the original judge, but he was the judge who was ultimately appointed to it. And initially, he didn't seem to have a strong reaction to it, but we filed a motion to dismiss, and I think it was Ben Kamenetsky was representing Davis Polk for the company, and we went to go argue it, and it was pretty clear that the judge just didn't like the transaction. He didn't care so much what the agreement said. He said, I mean, his words were, it just offended him that this opportunity hadn't been offered to the other lenders. And it became pretty clear over the course of the hearing that, notwithstanding what we thought were very strong arguments on the language, because here, I mean, if this had been a situation where, there was simply not a sacred right to prevent subordination, I don't think we would have gone forward with the transaction if it was just quiet on that. And you could certainly find authority to be able to do it. But here, having an express provision that allowed a majority to do it was, what really, I think, supported the transaction. But it was pretty clear that the judge was unhappy with it. And so, so we regrouped and we said, we're just going to offer the rest of the group we're not even going to try to settle with them. We're just going to offer them the opportunity. They've got 3 weeks. Hopefully they won't take us up on it. Then we can go back to court and say we offered it up to everybody. And then they did all take it. I think all but one. There was one very small holder that just didn't even bother. And so that was the end of the litigation. And then the company did not do well after that. So it actually worked out well for our clients because they had gotten back some of the new money that got put in. And then 6 months later, I ended up representing the full group of term lenders, including from both sides of the litigation. Yeah, and the rest of them, and it was a kind of an interesting mix because there were some very regular way lenders who were in the group who just were I mean the whole idea was just so shocking to them that this had happened. And then to be in a group with the very people that they had been litigating against. But we ultimately were able to restructure the matter out of court, found a seller. And in a way, it's kind of the story of LME in a sense of, starting with the transaction, the litigation, and ultimately getting to a restructuring.
Yeah, well, like the Astros World Series championship, there's an asterisk by it that it did not become the standard procedure. Well, the standard procedure for anything. And I remember so Octagon they own just $15 million. They're one of the minority lenders, and it was like such a small amount of money. But the general counsel and the portfolio manager both went on the record being interviewed saying, "Well, look, we're just against the principle of this, and we have stood up for the integrity of the market. So hopefully." All these lenders that are thinking about being creative in the credit documents are going to think twice, and this is never going to happen again. And that was the end of the story.
Yeah, no.
Right? No. So yeah. So to turn actually, so yeah, to actually set the record straight, Scott, could you go into what evolved after NYDJ in up tiers and
so I think it's LME is obviously broader than the up tiers, but what really it came down to is people realized that this was an effective way to address certain types of situations. And I think we can get into it. some of these tools are useful for certain situations and not for others, right? Like if you have if a company has a liquidity issue, certain tools are helpful. And if you have a duration issue that's coming up, like a deal like some of these 5149 deals, which is not really where LME is driving anymore, are not very useful. And so it's all about the document that you find in front of yourselves for the particular situation. And that's going to drive whether you're doing an uptier, whether you're doing an NGRS, a non-guarantor restricted subsidiary type financing, an unsub, a drop down. But what it all drives to is trying to find a pool of valuable assets or a way for the lenders to increase their attachment point in the credit. And ultimately, from like the creditor's perspective and from the borrower's perspective, what's easiest and best is if you can do the uptier, right? From an execution standpoint, particularly if the document is clear, or maybe some of the documents are less clear even than NYDJ, but people are pretty comfortable now if changing pro rata is not a sacred right, that it's not a sacred right. And you can do that. And that's really the easiest way to increase attachment point if you're doing a deal where you're not bringing everyone along, right? If everyone's coming along in the secured class, you haven't really changed your attachment point there. But if you can't do that, because it's, and what you saw in Serta, right? Like it was a fundamental right. And so in Serta, they said, we've got this open market repurchase provision, which is a way to structure around that. And that's obviously subject to litigation now. And if you don't have that, or what you're looking to do, as some of the lenders in Serta were looking to do, is do a J.Crew style transaction where you're going to move IP or other assets out. You can do that if the documents allow the flexibility, or you have like Envision where you can stack a bunch of baskets together and create a really, really big capacity to move a business unit out. But what you need to do there, and why it's much more expensive for a company to execute, is you're effectively doing a corporate carve out then. And you need to put in place TSAs, and you need to, create separate, especially if it's in an unsub, separate books and records and separate teams. And that all just takes time. So if you need to execute quickly, that's not necessarily going to be the thing that you do for your liquidity issue. But it's really, in my mind, the liquidity issue where moving assets away and doing a 5149 deal is really helpful. Otherwise, people, if they're doing it, and you see far less of people doing that because of the litigation overhang, and most of the time people are looking to get a deal that you get consensus around. And some of these tools really are the threat, right? It's the leverage to prevent the holdouts and the people from free riding into the situation. And that's really what we've been seeing evolve to where, like, you had those deals, like the COVID era deals, which were 5149 deals. Most of the deals that we're executing on now for clients and that we're seeing other people execute on, they're using these tools not to really do that. For the most part, 5149 deal. And then you also have on the creditor side of things, right? You've got the co-ops, and maybe I'm skipping around on our little agenda, but like the co-ops are being set up to effectively protect each other, like for the lenders, the creditors, to try to protect each other from that happening to them.
Yeah. I mean, far be it from the, the market, not trying to get cute with the credit agreement to get preferred treatment versus their similarly situated creditors. Yeah. There's all sorts of creativity that happened. Right. Followed by, there was the open market purchase first. And then, like once that's shut down, there's Serta blockers that came out. There's no NYDJ blocker. Right. That's why I feel like this is, this is an undercovered, innovative transaction. But then it's the payment prioritization, right? First out, second out, third out. So you start doing all these creative things. And this has led to a lot more interesting litigation. And that's where Erica comes in here and has been part of a lot of the more interesting ones, including Robertshaw and Serta in some ways. And so, Erica, how would you look at this from a litigation standpoint? And the risk of, and how do sponsors weigh the risk of doing this type of non-pro rata transaction?
Sure. So, I mean, the NYDJ story is fascinating, right? And Sid and I have spent hours going over the transcript of his argument and what Judge Ramos was thinking. And I think it really underscores that no matter how confident you feel about what's in your documents, and no matter how confident you feel about your reading of those documents, you don't know how a judge is going to react to a particular transaction that's before them. And in particular, especially, and I think we've seen this with many of the New York trial court rulings, if you're in front of a judge that does not have a background in finance, that is not, Scott Selinger, the wizard of LMEs, you're just not sure how they're going to perceive something. And you have to really take that into account when you're thinking about any type of transaction that you might do. And that's why really, litigation risk, we're hearing that is being priced into LMEs. People are thinking about what the risk is. But part of the analysis that we look at, because I do not only just spend my time litigating, I sometimes collaborate with these guys when we're thinking about transactions to think about how can we avoid litigation down the road. And you want to think about not just what are we trying to achieve here and what's necessary to achieve that, but is anything we're doing with this transaction, any features of it, are they not actually necessary for our ultimate goal? And how might a court perceive that, right? And an example of that, what we've seen, the courts react very strongly to amendments to the no action clauses in various credit agreements, where they say, well, what really was the point of amending the no action clause other than to try to prevent someone from bringing litigation to challenge this transaction? Or at least that's the reaction that some judges have had to it very strongly, right?
Like both Trimark and Boardriders.
Boardriders, right? And so the judges said, I'm not going to let that prevent these, the excluded lenders from bringing this lawsuit. And it kind of just, may lead to a judge having more questions about a transaction. But that's why, when I talk to Scott sometimes, Scott's saying, it's so clear what the read of this document is. I don't understand any other reading of this, right? It's very clear. And it's important, though, to have that context. And certainly, once you get into a litigation, that's all going to become much more relevant. But when you're at the outset, at the motion to dismiss stage, the court's not taking into account the broader context. If they don't personally have that background, the judge isn't looking at it the way that a finance lawyer might look at it, a restructuring lawyer might look at it. And you need to be thoughtful about that, because once a claim is passed the motion to dismiss, you're in it for the long haul. It's going to be a lot more drain on the company, time-wise, money-wise, and that's going to make a big difference. So these are all things we have to think about, I think, when we're looking at transactions.
Yeah, and in NYDJ, it was easy. It was just, all right, pro rata, right? But like subsequently, what we saw is like, okay, the way to get around litigation is let's cut everyone in some way, right? So it's like there is the first in, second, the coercive tiered exchanges and technology like that make sure that everyone's going to participate in some way, shape, or form, or risk being effectively unsecured. Sid, like in the immediate aftermath of NYDJ, right? What did you see in terms of, okay, well, there's a reaction by the market when drafting credit agreements and deal structure?
Well, I think that, I think the initial focus and that we really sort of brought, to the forefront was, for anybody who's investing that doesn't have a control position, you really need to think about it as if you were a minority shareholder. You have to read a document and just assume that anything is up for grabs unless you have really, really solid protection. But I think what happened was, as especially with the very sophisticated clients who invest in debt is, they really saw the opportunities that it created. And so what you had, I remember during NYDJ, I was partners with Scott Greenberg at the time. And, when I described the transaction to him, he looked at me like my head had fallen off. And, obviously Scott's made quite a mark in the LME space over time. And I think that, what people saw was the opportunity that existed to be able to effectuate these transactions.
Real white light moment there.
Yeah. And so you had like NYDJ, to me, Serta was kind of a combination of what happened in NYDJ and also what happened at the end of J.Crew. I mean, J.Crew is, of course, most known for the drop-down aspect of the transaction, but the part of it that I think is the most lasting was the way that it ended up getting resolved, which was because they were going to lose the litigation. I mean, we were representing the term lender, so I say this with some bias, but they were going to lose the litigation on the drop-down. And so what they did is they put forward, and their group had, the mezzanine had 30% of the first loan. And so they put forward an offer to purchase 10% on a non-pro rata basis, only to the consenting lenders. And they did it over a 4-day period, and they were able to get 88% through that process. And so I think when you combine sort of that sort of repurchase aspect with what happened in NYDJ, those two features together are kind of what led to Serta, in a sense, where you have the open market purchase tool being used to effectuate the uptier.
Yeah. And Scott, Serta litigation continues to this day. And I like, you did, it does depend on the judge, right? You remember Judge Jones is like, oh man, that's completely unambiguous. Open market purchase means privately negotiated purchase. Like in your background is LevFin.
Yeah.
Right. When did you start making this transition more and more into working with the restructuring groups? And looking at this in terms of, wow, these loose credit documents have ushered in a whole new era of liability management.
Yeah, when did I become like a full life cycle of the credit lawyer is really the question. As probably 2018, 2019, we started doing, deals that we were looking at for clients that involved this kind of up-tiering for liquidity or other issues. And it started with that, and then it kind of morphed over time as people were looking for different pockets of assets and collateral in order to do these deals. And kind of over that time period, right, like kind of part of your last question is sort of like, never really heard of an NYDJ blocker, right? Like that's not something you hear, but you obviously hear blockers about like a lot of these other transactions. And like J.Crew is really probably the first one where people started immediately talking about putting blockers in documents and like, but the evolution of like how prevalent or acceptable those were in documents and how much, sponsors and borrowers had to agree to those was really a much longer drip in terms of like how the market thought about it. And part of it is we were still in a pretty frothy market when those things happen. And so, yeah, you'd see certainly in like private credit deals, people would put it in. Also, many of the private credit deals back in 17, 18 were small, right? Like now you have some mega unitranches that like, for all intents and purposes, have syndicates that are as big as some, syndicated loan, groups. So you didn't really see that in the BSL deals I was doing at that point in time. Like you weren't really seeing sponsors having to agree to J.Crew protection. They weren't agreeing to J.Crew protection. Maybe like if you needed inflex, and it was like, I've certainly had a deal that was like, there was no IP like that. That's kind of, I always found J.Crew to be interesting, and it's kind of proved itself out that these J.Crew blockers that were about, no material IP moving was kind of like, after the shoe bomber when everyone had to take their shoes off in the airport, as if that's the only way in which somebody can like do harm. And obviously like now in today's day and age, certainly in like a distressed LME, post LME credit, you're going to see a J.Crew blocker that really just blocks moving any material assets, which is really like, an
everything blocker.
An everything blocker, right? Like you have two options. You either should negotiate as a creditor investment baskets in a way that makes sense, or you kind of don't give the investment baskets and don't have a blocker, or certainly don't have a blocker that like is so limited as you kind of think about it intellectually. And then as time progressed, obviously there was the Chewy blocker, right? Like Petsmart, did a variation of what, Caesars had done where like, they unguaranteed by moving kind of one share out. And so then you'd have a blocker around that. And then Serta, really post Serta, that was the first time like really heard about people putting in these uptier blockers and becoming really focused on the subordination of the liens. And even there, like in part because Serta happened in the midst of like the very frothy market that emerged after the, initial seizing of markets post the COVID lockdown, and like money was flying. And so really it wasn't until I felt like when the market seized up post the Ukraine war that you really started seeing Serta blockers go from being in private credit deals and deals that were kind of distressed. Certainly if someone had to get like covenant relief during that time period, that, you had to agree to a Serta blocker there. But I think when the syndicated loan market kind of reemerged, or the deals that tried to clear that were like long post the Ukraine war seizing up of the market, then you really started to see the blockers. And then it became a question of like, what should this blocker look like? And really what I think you find in most of these, certainly in the big syndicated loan space, but more generally, the right answer for the blockers, in my opinion, is what they ended up doing in NYDJ, which is you can do an up tier, you could subordinate, so long as everyone got an opportunity to participate. There's some exceptions to that, an exception for a dip, exceptions around things that are really meant to be senior, like securitizations, things of that flavor and variety. And then you went to the next thing, right? You went to stacking of the baskets to an unsub, that's bad. So you see an Envision blocker, and there are different flavors of those Envision blockers. You see people use, the voting as a way, like the entry consents. And so people block entry consents and so on and so forth. So what you get to today's market is people are asking for the omni blocker, right? Like,
and that's tough, right?
I don't want to have to think about anything else. And so I'm just going to say, like, you're not going to do it's effectively, if you put it down to one sentence, they want a covenant that says you won't do LME. And is that really the right answer? Is probably not really the right answer, depending on how you construct it for anyone. Like, right? Like, that's one of the things to talk about is like, is it really like old school credit lawyers back when you didn't have big syndicates and like they were like what some private credit was, in 17, where you only had to go talk to 2 or 3 people and they were your partners. Like, then everyone having a say made sense, or maybe made sense. But when you have these huge groups, or like, a unitranche with 38 guys that I've got a deal right now, which has got a huge kind of unitranche, do you really need to have to get everyone? So the answer is like, that doesn't make sense for even the other creditors to have somebody have the kind of holdup value to be able to have a gun to like literally everybody else in the situation's head of like, pay me basically the cost that it's going to take the company through Chapter 11, because that's what you're going to have to do to stuff me. And so give me that, $5-10 million.
I'll save you a bunch of money.
I'll save you a bunch of money.
Just
and
give that to me. And
like, that's not the right answer, which is really why I think people who are thoughtful about it on both sides of the table should say, like, at worst, it's got to be the pro rata offer. It can't be the kind of thing, or it doesn't make sense to me for it to be the kind of thing where literally people actually have the right to hold it up in something that you have otherwise pretty broad consensus from the capital stack around doing.
And taking it to the next step, I mean, this is what we've been seeing in some of our deals, situations where the company needs new money. And having the tools to make sure not just that people aren't, blocking, but they're actually going to write checks. And if they don't participate, having the right kind of hammers in place, including, tools that, for example, would allow, those that participate, to get preferred stock, for example, that might be ahead of, left behind debt. I think we're going to see as, with what's happening in the private credit markets, to the extent that there's hesitation to be putting new capital into those kinds of deals, some of these tools could be very effective to to sort of flush out that capital.
Yeah, it's a bigger and bigger private credit restructurings, reporting them here. Like Pluralsight was the start of like, oh, maybe there's going to be some LME technology in private credit. Oh, no, never mind, hand over the keys. Right. But now it's like, it's going to happen. We've noticed at NYDJ, the way we cover it here is that like neither is the market going to just be like, oh, hey, man, like, you know what? No more LMEs. So it's just not fair to different creditors, nor are our sponsors going to be like, oh, you know what? You can do whatever you want, right? It is going to be something where there is this push and pull. The market is going to allow for the looseness of these credit documents. The most interesting thing, the J.Crew blocker you bring up right now is like, people have been planning on doing a Xerox style deal for quite some time because all it specifies is don't put a bunch of IP into an unrestricted subsidiary. So let's just do a JV. It doesn't say subsidiary, right? There's ways around all these things. You think about this when you're advising clients.
Sometimes thinking it through. What's possible?
Yeah.
Sometimes Sid will call me. He'll say, "Well, what would Andrew Glenn? What would his best argument be opposing this? Or Jennifer Salendi? What would she come up with?" Right? And you need to think about it from both sides, right? And that's why you really need to look through all of the document and think about how the different provisions work together and what's someone going to seize on.
Yeah. Ultimately, people are deploying capital on all sides of the table, and they're looking for ways to protect their investment and, buy runway where they need to buy runway, buy liquidity where they need to buy liquidity. And on the flip side, the creditors also, they've got capital at risk, and they're going to look for ways to defend the capital and, if they can, avoid having, capital come ahead of them. But ultimately, it's like you were saying, there's got to be a give and take.
It's so interesting because on both sides, instead of it being like, okay, let's never try this again, just the technology has become so much more sophisticated, right? There's, on the new issue market, there's all these blockers that are being devised and insisted upon by creditors. But then there's also these voting caps and these holding caps and these concentration caps and, the attempt to put anti-co-op language in to prevent creditors from having leverage in the subsequent restructuring negotiations. And both things are happening at the same time. So, when it comes time to actually do an LME, maybe we're exactly where we were in 2020. The docs are still loose enough to do something that's non-pro rata. But it's just the cost of litigation, and you got to cut people in at least a little bit. And it's never just been like, oh, kinder, gentler now. It's always like, well, we're doing a pro rata deal, but with a 10-point backstop fee.
Right.
Is 10 points too much?
Right.
And then if it's not,
you feel it out.
You feel it out.
And you see how it goes. And you see if you get pushback, and you be prepared to, know what your next counter is going to be and what's your fallback. And you just kind of think through all the iterations of where things might go.
Right. And it's going to actually get edgier, right? Like that's what Xerox proves is like, if you have the blockers, smart people are going to spend a lot of time trying to figure out what their avenues are and optionality. And so, it's probably worse for everyone that the assets are sitting in a JV versus in an unsub where at least your borrower
except TPG.
Exactly. But so you're going to get different flavors and variations, and it makes sense that people are looking to protect themselves, but that's what's going on all sides of the table.
And that's what we do as an industry, right? We kind of evolve and we think about the next technology and we take it a step further and a step further, and then maybe litigation knocks us back. It's a little bit of whack-a-mole, and then we kind of go in a different direction, right?
Yeah. Robertshaw definitely taught people to give slice everyone in just a little bit, at least from the get-go. So kind of to start tying things, in a bow here, NYDJ is kind of an interesting example of something that worked. It's like one of the few that didn't have to go through a full in-court Chapter 11. Right? It was out of court.
I mean, it worked in the sense that it got to an end where there was a restructuring and what was supposed to happen happened, and it didn't even have to go through a bankruptcy to get there. Look, it obviously let the genie out of the bottle. I think people had been thinking about these kinds of things for a long time. And so it was really maybe, it was the first, obviously not the last. But I do think, the kind of the story of how it ended up, and it all happened in a more expedited way than what we see now, and in some of the cases that have gone up and
6 years later, Serta,
right.
at trial this morning, right?
It's like in the NYFin, we don't even have a company page for NYDJ. It's still out there. They're still selling jeans, right? It looks great. And Serta is still selling mattresses, but we've got about 6 or 7, different pages for them.
Well, I'm sure Sid would be happy to create a page because, as you can see, he lights up positively talking about this transaction. So,
oh yeah, really, really, really fortunate to have you here to talk about where and how it all started. We really look forward to having you on to talk about a lot of the transactions that are to come.
Thank you for having us.
Thank you.
Thank you very much.
Thank you all. And that's a wrap for Cloud9Fin.